Assalamualaikum and good morning to Dr. Nadia. This is Group 12 and we are doing a case review on the topic of Lian and Jual Janji, and the case is RHB Bank Berhad and Wong Kok Leong and others 2017. Lian is prescribed as a security transaction that generates an equitable interest in the land or property where a person intended to charge upon the property to secure the payment of specific debt. In the National Land Code 1965 is silent pertaining to the definition of Lian. Nevertheless, under Section 218, it outlines few requirements that needs to be satisfied in order to establish a Lian. Firstly, the deposit of the original issue document of title. Secondly, the intention to establish a Lian. And thirdly, the filing of a Lian holder's caveat. Thus, the application of Lian can be further discussed in the case of RHB Bank Berhad and Wong Kok Leong and others.
The registered owners of the land entered into a joint venture agreement with Tencong Enterprise to develop the land into a housing estate. The landowners issued first legal charge in favor of RHB Bank. However, the joint venture agreement was revoked due to Tencong's failure to repay the loan, so the bank terminated it and initiated legal action. The registered landowners made an agreement with a different contractor to complete the abandoned housing development. Titles were redeemed by the new contractor, but 54 titles remained with the caveat. The respondents filed an originating summons seeking the return of the 54 titles from the bank. They claimed that a sum of 58,212.5 cents were the remaining balance owed to the bank, while the bank asserted that the actual outstanding amount was 317,404.27 cents. In the Court of Appeal, the plaintiff sought a declaration from the court that the defendant was barred by limitations based on Sections 21 of the Limitation Act 1953. The Court of Appeal ultimately ruled that the lien holders' caveat placed by the bank were no longer valid and should be lifted, allowing the respondents to regain their titles. The appellant continued its appeal at the Federal Court.
There are two issues that arise in this case. Firstly, whether the defendant is barred by limitation from exercising its rights under lien holders' caveats. Secondly, whether lien holders' caveats are no longer sustainable.
Moving on to the decision of the case, the limitation in the matter at hand cannot be used as a cause of action, as was decided in Sakab Commodities, and the court fully agrees with this ruling. As a result, the Federal Court dismissed the Court of Appeal's order and accepted this appeal with costs. Costs are set at RM50,000 and are allocation dependent. Meanwhile, the deposit is refunded.
In this case, the judge gave his opinion about the standing of lien holders' position and the question of application regarding the limitation and specific ground in NLC. Lien holders' caveat is not able to be cancelled by limitation. In contrast, it can be cancelled by the circumstances in Section 331 National Land Code. In this case, the judge have the opinion that National Land Code that has the principle of circumstance that could determine the position of lien holders' caveat. Thus, there is no need for the Limitation Act 1953 to be applied because there is a specific related law pertaining to the issue, which cause there is no need for a general statutes provision application in this case, as this could be supported by a maxim, generalia non specialibus derogat, which provide that the general does not detract from the specific, as can be seen in the case luggage distributor Senvian Berhad against Tan Ho Teng and another. Gopal Sriram said that in this case, where there are two provisions of written law, one general and the other specific, then whether or not these two provisions are to be found in the same or different statutes, the special or specific provision excludes the operation of the general provision.